Dear friends, so today is our first lecture on dispute resolution. It's also is known as civil litigation, and this particular name was used for the QLTS purposes. Now, with the SQE, I think emphasizes on dispute resolution, which broadens the subject and to cover alternative dispute resolution from the point of view of the content of the assessment, so certain topics related to alternative dispute resolution and international, in the light of international claims and proceedings also were added. So just for your knowledge. Secondly, it took me time really to prepare for this particular session because I had to substantially amend the notes because many recent changes were introduced to the CPR rules, civil procedure rules that we are going to cover today. So just pay attention to that, and manuals for the SQE, at least those which I used, they are not really updated yet. So, but you may be assessed in the exam. Whatever training provider you are using, please check with them if they updated their materials too. And here with me today is Matt Canning. Hello, Matt.
Hi, everybody. Hi.
My congratulations to Matt. He recently passed the higher rights of audience in civil litigation in particular. Could you please explain to us what actually does it give to you and for people to know what it is?
Yes, definitely. Well, thanks very much for the congratulations, Olga. Well, it changes my title first, because now I'm not only a solicitor, but I'm also a solicitor advocate. Essentially, it gives me the exact same rights as a barrister to assist my clients up to the higher courts in civil litigation, which means that I can go to the High Court, the Court of Appeal, and all of that. Obviously, it's not necessarily something that I will do casually, because it requires experience, and passing the exam is not enough to have that experience. However, it can come in really handy to assist a barrister, for example. If my firm wants to instruct a barrister, I can become the junior barrister to help them. And also it gives me a broader experience in terms of how to instruct or brief a barrister.
But you first need to be a solicitor, right? So then, can I ask you, you actually passed both exams. What is the difference if we compare? Is the higher rights of audience exam more difficult in your opinion?
I'd say that it's different. It's different in terms of in-depth. So whilst the SQE covers broadly everything in civil litigation, the higher rights of audience, because it's for higher courts, will focus on those courts and on those procedures in relation to those courts. So Court of Appeal, Supreme Court, High Court, and that kind of stuff, really. And in terms of knowledge, a very in-depth knowledge of the CPR is required. So you really need to know the white book, which is the textbook of reference when it comes to civil litigation.
What about substantive law? Did you have to revise like contract tort as well?
So yes, you need to revise. You have to make submissions, and so for me, it was in contract, but it could have been in tort, and it can be any sorts of action, really.
Great. So my congratulations again, and you will be our expert today for dispute resolution.